Good afternoon now, everyone. Since we have passed the noon, but on a curfew day, all perched in their own homes, I hope all safe and healthy. Thank you for inviting me, Vestralex. I was, in fact, pretty much intrigued by the topic that I was suggested. What is a crime and who is a criminal? I would say that the answer to this question, in my humble understanding, keeps changing with time, place, amidst whom we are, and our understandings of the same situation over all these different factors. And I believe it will continue to change, albeit at a pace which probably we may not notice in our lifetimes at least. But why I say so is, for me, today's session is not anything which you normally would hear or listen in your classrooms, the real classrooms. Because as students of law, I would always want everyone to be inquisitive, always asking questions to the extent of sometimes irritating, but still, that inquisitiveness will lead to the development of law, the development of the society. This inquisitiveness is necessary for the development of mankind as such. Right from the times immemorial, ever since man attained consciousness, he has been looking at things, looking at conducts, and asking questions. Those could be on physical things or metaphysical things. And all these have resulted into codification of certain moral and certain other acts which have taken the shape of law. Now, over time, right and wrong were always discussed. And it was this right and wrong which started concretizing itself into things which could be left as just moral wrong, or things which the society of the moment felt should be punished. That punishment gave rise to what is called a crime. Now, as we would know, and all of you would have read, crime and these wrongs have been discussed right from our scriptures, be it our Dharma Shastras or be it the Ten Commandments or even the Code of Hammurabi, which is considered the first codified law. And then over time, nation states emerged, and the rulers of those nation states, be it monarchies, dictatorships, or democracies, all then codified and legislated laws. I, in fact, want all of you to understand crime has been considered in a very, very way that crime is treated as a very, very serious act. And the other wrongs which may be actionable wrongs, as you understand under the tort law, has been considered to be on a lesser footing as far as the penalties or penalizing them are concerned. Crime has been taken to be understood as something which has some kind of an impact, and it is a wrong against a person, harming him. But crime definitely has two elements to it: the act itself and the state of mind. And initially, when the modern criminal justice system started emerging, crime was considered a sort of a sickness. Crime was considered something which a mentally depraved person is trying to do. Whereas I would beg to differ, because probably our indigenous system of law and indigenous the Nyay system which we had in India was a much more evolved system, where we considered perhaps even the status of man's awareness as a part of what could be crime, or whether the same act could be considered as a crime or not. For that, I would just like to give you an illustration. There is a story in Mahabharata on understanding Nyay and crime. Yudhishthir was confronted with two people, both having stolen from the garden of the other person fruits. When he called both of them, he punished one and let the other person go with a reprimand. He was asked why he distinguished the two and made that distinction. He said one was an educated, intelligent person, and he did it for greed. The other person was an uneducated, his hunger drove him to take that fruit to eat. He could not consider the distinction between the theft and quelling his hunger. So he was not committing a crime. Now, those are things of the yore. Now, when we come back to today, these are not the things which our law books teach us. So, crime, what we understand, is an act or an omission which has been made punishable by law. It could be any law, not just the penal code, but any law for that time, for the purpose. Now, we can say a crime is anything that is stopped by law, an act or an omission which is made punishable by law. But is every person who commits that crime or that act, is he a criminal? Perhaps most of us would answer it as yes. But I would say the answer is no. The reason being, a criminal. Now, the problem is we are borrowing these words from a foreign language. A criminal must have and must denote some kind of a state of mind which is not in consonance with the honest, normal human being. And why I say so is, as students of law, you must have read several laws and cases where there is no mens rea required for the act to become an offense. And the most famous case on this subject was State of Maharashtra versus Mayor Hens George. Prior to 1980s, there was a law of Gold Control Act, which prohibited possession also of primary gold. And this person had primary gold with him while he was seated in an aircraft which had landed in India. And it was held that mens rea is not the requisite of the offense under gold control. But was he a criminal? I would say no, because he never intended it. That intention was never there to commit an offense. It may be a crime under the Indian laws, but from where he came, it was not a crime. So the place changed the whole complexion of his act. He may have been an offender, but is he a criminal? I would dare to say no. And perhaps that was the understanding by our lawmakers when they decided to remove that law. And later on, the Gold Control Act itself was repealed. So, crime and criminal are understood by the time, place, and the perception of the society. We go through our law books and understand what is a crime. But as law students and as lawyers or budding lawyers, all of you need to understand that perceptions may change. The same thing may be an offense today or may have been an offense yesterday, but today you can change the law for it. And the two stark examples on this have been the triple talaq, and where it has been added as a list in the list of criminal crimes. And the second one is decriminalization of homosexuality. See, we cannot live in a hangover of our past. We have to keep evolving. And law is a dynamic subject which all of you have to understand. And till the time you are inquisitive and you start questioning yourself, you will not be able to develop the law. And it is very important that we keep changing with times and keep abreast with the times to keep changing our laws. Things which were unheard of earlier in the past are becoming the norm of today. As technology moves on, we may have to change our laws regarding different things. Perhaps one of the archaic laws of which I have been very critical is Official Secrets Act. Is anything left a secret today? With the social media circulating everything? Is the law of sedition, does it not require some kind of an overhaul? See, when India became independent, Prevention of Corruption Act 1947 was made, and it had certain colonial touches to it. Still, the punishment was left to the judiciary. They could change the sentence to a bare minimum considering whatever the factors of mitigation were. But in 88, it had been felt by the lawmakers that corruption had become a very big problem. So they made it stricter. They made a minimum punishment there. But then again in 2018, in 30 years, it was felt that certain acts could be given a little let off. There were people who were being harassed. It was felt by the political masters. So they needed to put in some more safeguards. So they again reduced the rigors. They again brought in a different dimension to it. And the same act could have been an offense earlier, no more an offense. So one will have to keep on changing with time. Similarly, there is the repeated acts or repeat act behavior of the same pattern was not considered with severity. It was not considered with a harsher hand. But later on, these clauses have come. Laws like Mokoka, which came in Maharashtra, was adopted in Delhi, feeling that this kind of organized crime syndicates, they should be curbed. So something which was not an offense earlier becomes an offense now. Similarly, what is crime in India may not be a crime in US, or what is crime in US may not be a crime in India. On the lighter side, in US, a joke as amongst Indians which goes on is, you slap your child and he'll dial 911. So the man brings him back to India. When he comes back and he beats his child, कहता है अब मिला ले 911. So it's the parental discipline also has certain limits in that country. Whereas here, you probably would give it a miss. Nobody would call that man who is slapping his son a criminal, or nor would his act become a crime. So one must understand that the definition of crime or a criminal keeps changing with time, place, and the perceptions. The perception of people have driven certain things to become crimes, and perception of people has made things decriminalized also. So this good act and bad act aspect has to be studied with the time and place, with that much importance. If you see our scriptures, our epics, some of the acts may be considered illegal today, may be crimes. But in that time and that place and that age era, the society accepted them as a norm. Polygamy, polyandry, gambling, as it was called, Dyut Krida, was an accepted thing in our epics because that was the society it was. 1955, polygamy, polyandry was totally given a go by. It was made an offense. It is not permitted. Similarly, Gambling Act banned any sort of gambling which had money or any kind, anything done in kind as a game of chance. And the Constitution permitted that kind of an embargo being put. And the Supreme Court in RMD Chamar Bagwala's case, famous case, they accepted this, that the law can be imposed. So what we defined in our books, the crime could be against the person, crime could be against the property of that person, against his reputation, crime could be against the state, or crime could be something which is today a technical crime, or crime against the revenue. These were not concepts which were initially thought, but probably we have borrowed it from different cultures and different societies, and we need to run the societies and govern the systems. So those have become crime. But something which you need to see and understand, the definitions of crime keep changing, and as recent as the 2013 amendments which came in, we have seen the definition of offenses against women change, because it was felt that they should be curbed with a heavy hand. It was felt that women are being targeted and people have used the loopholes. So a stricter definition was brought in. A much wider definition of crime was brought in. And something which may interest the students of law, Juvenile Justice Act itself has undergone a sort of a seesaw. Initially, below 16 was the juvenile. Then the age was raised by the international conventions and the treaties India entered into, and it was raised to 18. After the uproar in the Nirbhaya case, it has again been reduced to consider it that if there is heinous crime, a niche has been carved out. So, what I want to only convey to you is, don't see crime or criminal as a definition in a straitjacket. Tomorrow, you may be instruments in bringing about a change in either enlarging the scope of what is a crime or reducing the scope of what is a crime. And similarly, those who commit that act may just pass through with a minor punishment, just a fine, or it may be the sentence is enhanced. The fiscal statutes prescribe, sometimes without mens rea, that any kind of evasion of tax or the cess is considered a punishment of under criminal law. Whereas certain statutes require the act to be willful and deliberate. That is why I said that there is a difference in what is a crime and what is a criminal. Simply because a person who is committing the crime, he doesn't become a criminal. I know how many have undertaken the task of even following up. There has been a movement in US regarding making marijuana available off the counter. If we go back in time, in India, afim or opium and bhang and ganja were freely available before India became a signatory to international treaties on drugs. The contrabands were introduced. And NDPS Act came into the picture. After NDPS Act, there were several other notifications in that. So the act which was normally not a crime became a crime. So we have to understand that of that moment, whether it was a crime, whether it was against the law on the, and then you can, when things become archaic, you can get it changed. That is the job of the lawyers. We are presumed and expected to be the interface between the society and law. And we have to do this activity probably with more passion to keep up with the what is happening in the society. The LGBT societies were actively involved in changing this, decriminalizing the homosexuality. Now there is a movement going on for making marijuana and certain other drugs available to people. On the contrary, the governments, one after the other, have added things to the list which people found. And I don't know about you people, but at our time, when we now, this is on the aside, this is nothing to do going on the record, but when the hostlers and us, we found ourselves short in getting some kind of alcoholic beverage, the cough syrups were used because they were having an amount of alcohol. Today, the governments time and again have issued notifications, and different medicines which were available across the counter, over the counter on a prescription, things like tramadol, have now become offenses. And surprisingly for you, you would find dealers and distributors who had stocks lying with them, unsold stocks, were raided after the that brief period of 3 months or 4 months, I think they gave, and immediately thereafter they started raiding them. Obviously, the government had some information where the stocks are lying, and those people are arrested and they are put behind bars. They may keep on crying hoarse that they are not criminals, but they are painted sometimes with the same brush. So it's the duties on the lawyers to show and bring out what's the correct color. I had already told the organizers I don't want to go on the script of the curriculum of crime and criminal, but I would like to just incite that fire in your bellies to basically be inquisitive about it. And just as a final thought and a food for thought for all of you, if any one of you is interested in crime and criminal, the criminal law aspect of it, something which I have been working on for the last, say, 15, 20 years, I've not had the opportunity to address it in any appropriate case. But please go through the definition of offense under the IPC, which is under section 40, and go through the definition of offense under the CRPC, which is under 2N of the definition clause. The two are different. Somehow, we have not had the occasion of someone dichotomizing it, because 2N is a wider definition. It includes special laws also. And that's why the procedural code allows the same procedure to be adopted for the special statutes. But IPC, the offense, has a narrower definition and allows the offense word to be used for some of these provisions for special laws, not for all the provisions. So just as an exercise for your minds, I leave it at that as students of law, if you can marshal out the difference between the two and probably utilize it, because you would find in many of the provisions, we loosely use the word offense. Whether something does become a crime if you do use it conjunctively with the IPC or not, may be helpful for you as well as for the society as a whole. Because according to me, crime has a very, very different connotation in the mind of every different individual. And that's why the general defenses have been put, which allows things to be, even which are trivia, to be excused, things which have been done under rage to be excused, things which are done under a mistaken belief to be excused. Now, how far are we able to utilize it is a very different concept. And trial by media and trial in this social media today is making it only more difficult. So the onus will be on all of you to carry on this baton of redefining and defining crime and criminal law and who's a criminal, so that people are not unnecessarily condemned even before they get a fair hearing. Thank you for listening to me, and I'm open to any questions if there are any. Over to you, Keshav.
So very insightful indeed.
Keshav, I have a question.
Yes, sir, please.
This is Abhishek Singh, advocate from Bombay High Court, practicing at Bombay High Court. Sir, can you elaborate on 4 stages of crime?
See, 4 stages, if you try to talk of preparation, attempt, and the execution of that act, then that's why I said I did not want to venture into any of the academics, but wanted to deal with things which are probably neither in the law books nor discussed. So Abhishek, I can discuss this with you. You can take my number from Keshav,
All right,
and
sir.
you can call me up, because I did not want actually that we start discussing academics here, because
Okay,
उसमें कोई फायदा नहीं, आप सबने पढ़ी हुई है.
okay, sir. Okay.
The preparation stage will not be the thought which comes to your mind, the preparation which happens in that, the attempt that you make towards it, the furtherance of the act, the implementation itself. And then there is, according to me, a 5th stage also,
Yes, sir.
which I have recently used, and in a bail application. Now, this is on the aside, and that is reflex repentance.
Okay.
I have this, I coined myself that I may have acted, though at that time I acted with full deliberation.
Okay.
But then suddenly I have a reflex repentance. After
Okay.
having committed the act, I repent. Would that mitigate my case? So, on the academic side, Abhishek, you are free to talk to me anytime. But that's why I left you with a food for thought. If you ever get a chance to read section 40 and then section 2N. 2N is a much wider thing. 40 May, you will find that the word local and special laws is only reduced to a particular few sections in different chapters. So would
Correct.
120B, when it talks of an offense, would it include the offenses of special law? Is something which probably all of you may be able to develop it further. I have tried to develop it, that 120B is not included in the word special laws when you read section 40.
Okay.
So just if you get a chance, please read it.
Okay,
Special
sir.
law, IPC only says offenses under the code,
Correct.
but carves out an exception for few sections, few provisions of law, which does not include 120B. But you will find everywhere 120B is being used.
Correct, sir. Correct.
So when you see conspiracy does not include the other offenses. When you see the section 40.
Yes, sir.
So offense, when you would read it, an offense under 120B, it has to be read as an offense under section 40. But 40 does not include special laws for 120B. So how can you add 120B for other offenses? But problem is, if we use this argument in a very, very cavalier fashion, it might just get dismissed. And then
Okay.
it will be stamped forever. So I did not venture to do it. So academics के लिए तो ना, we can have a full class. क्या मतलब, we can have a discussion for hours and hours together.
Sir, if you can just shed 2 minutes of your time, sir, on this particular thought that you were mentioning. The thought which comes after the crime, after the 4 stages, the one which you have mentioned, sir. It's
Kesha,
very, very.
this was actually developed by me in just as an argument to a query from the court. The man, under an impression that he is being attacked, he attacks another person whom he feels that he has brought these people. Actually, there were 3 groups. He didn't realize that. So he attacks this man thinking that these other people who have come to attack, who had just they were coming towards him, he starts beating this fellow. This is all captured by the video, the CCTV. Then suddenly he sees that those people have come to beat that person. So he backtracks. He had thought that he has stabbed him in his back, but then he backtracks and he saves this person from those people. It's all captured by the CCTV. Now case is foisted on him of attempt to murder. He shows the CCTV was the arm of the weapon of the prosecution. They said he beat him. But when you see the full CCTV, you find him saving also. So the court asked, what kind of a behavior is this? Because you have clearly beaten him. It is clearly seen from the video. Then I argued that sometimes, so there by change of heart is actually sometimes happening in a split second, that the thing comes into my mind that there is a reflex action is, okay, what the hell am I doing? Probably I am wrong. I didn't understand. These people have actually come for him, not for me. So he starts saving him so that nothing untoward happens. Now, during trial, it might show, because when you are trying to derive intention of the man, was that intention always there to beat him? Because that will determine the 307 or 308, the attempt. Because it would not be an attempt if he had no premeditated mind to hurt him. So my subsequent conduct, which is also a part, if you see the section 8, res geste of Evidence Act, the subsequent conduct is also important in a relevant part. So we have to merge all these aspects when we develop law. And that's why I said crime, criminal, these are ever changing, ever evolving concepts. So,
Most definitely, sir. So also, sir, there are definitely other feedback also coming that so you've actually uh, made us now be in that position to actively differentiate between the crime and the criminal. Generally, तो सर यही एक थॉट चलता है कि जो पकड़ा गया वो क्रिमिनल, लेकिन सर यहाँ पर यू एक्चुअली very I would say very clearly differentiated that these are very, very different things. And when
but
we have
one thing, Keshav, which you were asking me about
Yes, sir.
the retributive and the reformative theories. See, these are basically sentencing functions. So first you have to establish the crime itself. And then perhaps manthan karke ye dekhna padega that whether the man is a criminal and requires reformation, or whether a deterrence kind of a theory is required. So those are things which one will have to examine. And that's why I said a food for thought for the law students. Law books mein hum padhte hain that there are general defenses. But when it comes to the application, unfortunately, barring private defense and alibi, we forget everything else. Mistake of fact is a very, very important aspect. triviality, section 95 IPC. Because in technical offenses, triviality plays a big role. And if you students of Google can Google it, there have been n number of judgments where at least the high courts have used 95 IPC as a ground to acquit people and let them re-establish themselves in society, because very, very minor acts have been penalized because there are minimum offenses, minimum sentence offenses, like food adulteration for a matter. Food adulteration has a minimum sentence of 6 months or 1 year, I think, the new act. How do you get out of it? The man may have acted in a manner which may be so absolutely trivially wrong. The wrong committed by him was so trivial that one would excuse him. So in those kind of situations, you got to consider that aspect and take it out from the fold of being a crime. So these are things which you got to see, because the retributive, the deterrence, reformative, all these theories would come in only when you are talking about the man having become the crime having been committed already.
Sir, but continuing with this, sir, there is another question, sir, for your opinion, sir. So this is from Mr. Sumiteshwar Chaudhary. He is also an advocate practicing in New Delhi. And Sumiteshwar, sir, if you want to put the question before, sir, I think it's best that you put it before. So it's just an opinion that I think he has asked.
I have a
Sumiteshwar,
query, sir.
are we-
What is your opinion about matrimonial rape, especially when amicus curiae are in favor of removing the exceptions?
Actually, this is an area where, though the amicus curiae, Rebecca ma'am, was my senior in law and my senior in the chamber also. We come from the same chamber. And I have very high regard for her.
Okay.
But somehow I may not agree on removing all these exceptions immediately. Perhaps the kind of foisting of offenses we see in the cases coming for 406, 498A today has not given me the courage to remove this. Because what we find is when the allegations become so absurd at times, and the proof of such a thing, of matrimonial rape, will be a problem for all, because things happening inside the four walls of a room between a husband and a wife, the more it is difficult to prove it, it is equally difficult to disprove it. Because when you have the law with regard to rape and the crime against women, the Evidence Act making presumptions, and the presumptions casting the onus, reversing the onus onto the accused, it will become a very, very difficult area, because you will not be able to, I would say, cull out the grain from the chaff, because you will have a huge problem. Today, uh, it is the lawyers on both sides. The lawyers are advised these drafting of these complaints, and one line of rape being added. Today, we find, and as students of law, Mr. Chaudhary, you will also know, you would have come across cases where after the definition of rape has been enlarged, and the Supreme Court saying this skin to skin contact is nothing, it's all to be not to be considered. And any kind of a physical act would tantamount to rape after the enlargement of the definition of 375. It will be impossible for an accused, in my humble submission, that my opinion immediately would not be for removal of this, because our society has still not evolved to such truthfulness and such uh, kind of a credence where we have the crime rate and see the conviction rate and the evidence that comes forth. See, 406, 498A, I do not know the statistics now, but there was a time that where 85 to 90% cases were ending in settlements. You add one line of rape, of marital rape, how do you get it quashed? How do you settle it? It will never be settled. And the entire procedure will change. If the marital rape concept comes in, then you are changing the entire procedure. The onus will shift. Everything will happen. It will be a totally. So I don't agree with her for this at this moment for the time being. Probably, whether in our lifetime or otherwise, a sea change may happen in this society, evolution of perceptions. We may be in for accepting marital rape as a concept. But today, it will most likely become another weapon. And with the kind of things which are happening, I don't condemn the women who are poor ladies who are sometimes actually being brutally handled by their menfolk. And some of the cases I've seen, there is truly a need for such a change. But still, if one sees the larger aspect of it, I don't know. I dare not think about it right now, because I have my own opinion about it, and I feel that some other thing, but extending rape to it, a very difficult proposition. I don't know. 377 I have seen happening, but then that's my personal view. I can change if I am given the material to thinking about it. I am a lawyer, and I am willing to. I am open for conviction. I am open for change. But then sometimes the society needs to be ready for it. The kind either some kind of safeguards should be brought in, or it should not happen that we change the law in a knee-jerk reaction, and then we find ourselves in a bigger mess. जो मैट्रिमोनियल मैटर्स आज सेटल होते हैं, कल को वो सेटल होने भी बंद हो जाएंगे. With rape as an allegation, so I I really don't know, Mr. Chaudhary. You have opened a Pandora's box of discussion on this issue.
And sir, Delhi High Court also has decided that if someone is suffering from the cruelty at the hands of a spouse, he may opt for a divorce on the grounds of cruelty.
Abhishek, see, cruelty is there. It has been there ever since 498A was brought in. Cruelty could be in any form, mental, physical. So cruelty has been there as a ground, both for divorce as well as for initiating criminal action. I would say even this brutal handling sometimes may tantamount to some hurt or probably grievous hurt also, because sometimes the women are being subjected to all kinds of nonsense. And with the kind of stressed environment that all of us in our society are living, there are reactions by the men and women against each other in a very violent form. So I am not against making it more stringent. You increase the sentence, or you make the test more tighter. So to that extent, I am with the women activists and whoever is working on that score. I am full for that, because nobody has a right to become physical and violent in any kind of a civilized society. And more so in India, where our culture does not permit it. See, ultimately, we are all born and brought up with that kind of thinking in our minds. It, cruelty and this kind of physical violence is unacceptable in all forms. But putting it in any kind of a codified provision, probably I would beg to differ.
So there is a comment from Mr. Chaudhary himself. He has thanked you, sir, and he really says that he appreciates the fact that you have answered the question from your heart.
Sir, I am extremely delighted.
Thank you, Mr. Chaudhary. I don't know whether all other participants would accept my views, but those are my views. I am open to change. I am open to.
I absolutely concur, sir. I salute
And,
you
sir,
for speaking your mind.
So I think Yogesh sir also wants to say that.
Yeah, myself, Keshav Sharma from Chhattisgarh, Bilaspur. And here in Bemetara, we have seen there are 15 cases were registered for the offense under section 498A. And in all those cases, 377 is also added. This is the misuse. And in the same police station, 376 was also added in one case, wherein a wife was living separately for more than 3 years. Then thereafter, in counseling at police station, she went with her husband, and just within 7 to 10 days, she again lodged a report of 377, 498, and with 376. Then we challenged it before High Court, and High Court has a quest for particular 376 offense, but continued with 377 and other sections. But this is misuse. So what you say, expressed, yes, we also respect the feelings, emotions of women, and we also want there should be some protection should be given to them, and culprits should be punished also. But what will be the criteria? Because it is not easier like other offences. What my learned friend senior has pointed out, I fully agree with him. It's not a simple way we can impose anything. It's a very huge subject, and if someone is asking, then they should be given opportunity to hearing, and they should be respected. But in blanket way, it can't be imposed. We will discuss it in the subject.
Thank you, Yogeshji. It only helps in my understanding it better, that if it is happening in even places like Bilaspur, then that means it is happening across the length and breadth of the country.
That is the reason why we are not getting accused. We are not getting bail on 498, and person has to approach High Court. Normally, district courts were used to refuse, but then thereafter the High Court, Supreme Court has given us protection. Yes, firstly the case should be sent to counseling. And now that is a scenario is changed. Earlier it was that once a person is inside, then he don't want to make a compromise for a future. हो गया एक बार जेल जो होना था. So, but there are so many things, and particular for this, need enough time to discuss this. And I appreciate your speech. I was hearing. Oh, very nice. Thank you. And there are so many other aspects also. What were the person if India and then England? I was listening very sincerely, and I enjoyed it. Thank you.
Thank you.
So Yogesh sir is also one of the member executives of the Honorable Chhattisgarh High Court Bar Association, and so sir, it's really again sir, as you also said, sir, this is a very humble initiative wherein we are trying to bring together the entire country, sir. We're conducting 25 classes, free legal literacy classes, on law, and we're trying to get 25 various advocates, different advocates, all very experienced advocates, such as yourself and Yogesh sir. And so how we had Dr. Nirmal Kumar Shukla sir also, who was there for the class prior to your class. And it was so unfortunate, sir, that we just could not introduce. Otherwise, I really wanted to introduce you to Nirmal sir also. And sir, Nirmal sir was also suggested to and referred by Yogesh sir. So it was really a great thing how this happened. And sir, how you very rightfully pointed out that the law is exactly the same in the entire country. All practices, procedures, even the problems and issues that are there, they're also similar for the entire country. So we also require your blessings, sir. Everyone who's here, all the participants also who are here, and so most definitely all the distinguished guests who are coming and conducting these classes, to be able to at least fulfill this particular task that we have taken up, sir. We have conducted classes for 3 weeks now, and we are still planning on about 10 more weeks and trying to cover the entire nation in this one particular initiative.
Keshav, it's actually a great initiative. The only thing is, today's classroom, as far as mine was concerned, I told you I work more on what is the practicality, because according to me, the nuances of the law will only be understood in practice and not in the theory. So, classroom for me is like where you open your mind. Just open your mind and allow things to happen and allow things to be questioned. So, that's how I perceive things, and that's why I told you that I would rather do a thing which can practically help people rather than anything on theory, because theory to kitabon mein likhi hai, anybody can read it and you can distinguish it, or you can have a one-to-one discussion. But for actually kindling that fire in your belly, you need to know the practical side of it. Thank you so
Most
much for
definitely, sir.
inviting.
And
Thank you.
thank you
Thank you.
so much, sir. It has been a wonderful pleasure, sir, and a great opportunity. And sir, to be honest, sir, there was so much more which came in this class that we hope to have your presence on as the distinguished guest who will be elaborating and helping us explore and expand our minds further.
Don't tell
Really
me
for
I
the
have
better.
I have left scope for sequels.
Sir, many, sir, actually for entire series. So with that, sir, I thank you, sir, on behalf of all the participants who are here, on behalf of our team, and on behalf of everyone who will be able to access this class later on in the future also.
Thank you.
Thank you
Thank you.
so much, sir.
Thank you.
And thanking every participant here again. 10 more weeks to come every Sunday, so the time is the same. So we'll be meeting between 11 a.m. and 12:45 p.m. Again, such distinguished guests, and we request you to kindly please share. This is a free legal literacy initiative. We are not allowed to promote. We are not allowed to market. We are not allowed to do anything. This is just word of mouth, guys. Please share with everyone who you know, so that more and more people can get access to such great gems of knowledge and in such candid environment.